The Nigerian Senate has issued a stern warning to suspended Senator Natasha Akpoti-Uduaghan to stay away from the National Assembly following a recent statement where she announced that she will be back to the Senate on July the 22nd, citing a federal high court judgment delivered by Justice Binta Nyako. The judgment she claims reinstates her as a senator.
Let's break it down now. Senator Natasha was suspended for 6 months over alleged misconduct during plenary. Now she claims the said recent federal high court judgment gives her the green light to return, but the Senate says not so fast. According to Senate spokesperson Yemi Adaramodu, the court ruling was merely advisory and not binding. Helping us to interpret what a court judgment is if it was advisory like they claim and not binding is lead counsel Robson Legal Osigwe Ahmed Momoh. Thank you very much for joining us this morning.
Thank you so much for having me.
Was that court judgment by Justice Binta Nyako, was it binding or advisory like they claim?
Yeah, it's definitely, well, it's quite tricky. To put a little bit of foundation, the challenge a lot of legal pundits are having here is that the judgment seemed to do by interlocutory means what ought to be done by permanent means. That sounds a little technical. Just to break it down, that seemed to be an interim or at least an interlocutory injunction that the courts ought to have given, but the wordings appear to be final. The difference between the interlocutory and the substantive or perpetual injunction seemed to be that if the matter started, the interlocutory injunction is one that ought to flow through when a substantive or a main matter is in court. So the court seemed to, from the judgment, seemed to have concluded the entirety of the matter from what ought to be a mere, interlocutory judgment. In other words, it ought to be a temporal relief to say, go back to your plenary, keep on, presiding over, keep on representing.
Okay, we seem to be, we will continue the conversation with Mr. Osigwe Ahmed Momoh, but we have a clip we want you to pay attention to, so let's take a look at the video.
I have written to the Senate again, telling them that I'm resuming on the 22nd, which is on Tuesday by the special grace of God. I will be there to resume because the court did make a decision on that. Now, they argue that it's an order. It's not an order, but it is a decision. And if you look at section 318, I think, of the Nigerian Constitution, it did mention that a recommendation forms part of a decision of a court. So whether it's a recommendation, a judicial decree, a sentence, or an order, they are all decisions, and decisions are binding on every Nigerian and every authority and every institution. So I'm going to be there live to attend. But I also know that the Senate will be going on recess very soon, maybe most likely next week for 2 months. That means by the time the Senate resumes, my 6 months would have lapsed. And I will go back, I will resume. And yeah, I don't hope there'll be any more resistance, because you can't apply you can't go against the, what is called double jeopardy rule, whereby you punish someone twice. So after the 6 months, you now go back to court or do extend or whatever, no, that will amount total abuse of power, which of course I do sense an abuse of power already, but that's for the courts and the public to judge. But so far, my people are not missing anything. As a matter of fact, I think we're one of the luckiest constituents so far. There's been a whole lot going on. We're all happy, and I'm really connected to my people and Nigerians as usual as well. I'm grateful for the love and prayers.
All right, we have with us Osigwe Ahmed Momoh, who's analyzing the judgment of the court. You were explaining the difference, why it's an interlocutory injunction of some sort, or whether it's an interlocutory injunction or a final one. Let's give you the floor to please go ahead with your analysis.
Oh, very well. So first of all, the matter, I think they approach the courts with a fundamental right proceeding, and a fundamental right ought to, focus entirely on fundamental rights. I think it's tricky for a court to even entertain, this matter through fundamental right, because your right to be a senator is not a fundamental right. right? Fundamental rights are those rights that are captured in a particular chapter of the Constitution. Anything outside that is not a fundamental right.
Okay, to respond to that.
What has a way of testing it?
To respond to that, can I maybe say that the fundamental rights here would be the fundamental rights of her constituents who have been deprived the right to representation at the Senate by virtue of the suspension that she was given?
Well, yeah, well, we can look at that, and then it will be the constituents who themselves will go on and say, well, you see, my fundamental right to be represented and heard have been denied, not necessarily that of the senator, right? And the court has a way of testing this. They test whether the substantive matter and the auxiliary matter, which of them is fundamental, right? Because sometimes your main grief, your main prayer may not be fundamental, but embedded in it may be some fundamental right issues like what you're looking into right now. And I think this is not the case. That was a strictly constitutional matter. It ought to have gone by originating some summons, and definitely not by a fundamental right application. That's my thought on that. But, you know, that's an aside. The point where many people have a little bit of confusion is as to whether this matter was brought by motion on notice, not an originating motion on notice. The trick here is that if it's an originating motion on, then the court can give a final judgment. But if it's an interlocutory or a motion on notice, which is asking for a temporal or interlocutory relief, because there are basically three kinds of injunction. One is interim by ex parte, a very short time, maybe 7 or 14 days, 7 days. Next is interlocutory, which is pending the substantive matter itself in court. Final one have to be the perpetual or substantive injunction. This matter appears to be that it was a matter that was interlocutory, yet it has the tone and the features and the semblance of a final
Mr. Momoh.
injunction. And I think that was definitely not the intention of even the person applying. Yes.
Mr. Momoh, I mean, personally, like I always
Very
say,
well, I can hear you.
I mean, personally, like I always say, a lot of Nigerians may not understand interlocutory, this, that, those. I mean, let's just. The question everyone wants to know now, and I'm sure people watching the show this morning, simply is: one, is Senator Natasha supposed to return to the House tomorrow using what the court had said? It's either a yes, she can't, a no, she can't, because of this reason. I mean, let's just see how we can break it down to the simplest form, please.
Thank you very much for that. Yeah, and I get that part, and that's why we've seen a lot of sentiment and emotion in this matter, not necessarily facts, you know, driving it, because I mean, these are mainly legal technicalities and all. Absolutely, I think once there's an order of the court, whether or not you agree, your first thought is to abide. It's not whether you agree with it, it's whether it's an order from the court, you ought to abide with it. And I think definitely the Senate ought, by every means necessary, abide by it, even if it's interlocutory, and seek further clarification. Whether in this is interlocutory, because interlocutory doesn't mean it shouldn't be answered. It should be answered pending. It means there's going to be a final one. You're not going to say, no, I don't agree with what the judge said, therefore, I'm going to run away from that. That's not how it works. That's not how it works. Definitely, I think the senator ought to be definitely in the National Assembly tomorrow, representing our people until and unless that matter has been jettisoned or vacationed. I mean, vacated rather. That's the only time where she should, refrain from doing what the court have said. And it is going to be sad. The Senate President is a lawyer. There are several lawyers there. We have the Attorney General of this country who is a very sound lawyer. And I think this is not the time for them to keep on allowing the judgment of the court go without power and might.
Now, Mr. Momoh, the Senate has also appealed this judgment. Does it mean that pending the determination of that appeal, that she can still resume? What are the implications of the appeal by the Senate?
Until there's a stay, and to the best of my knowledge, there's no stay. Until there is a direct order saying that judge order or the judgment from the court ought to be stayed, there's none to my that you have applied to appeal doesn't mean the judgment of the lower court has been vacated. That's not how it works. You only appeal while she's in the house. In any case, what do you have to lose? What do you have to lose if on appeal they say, no, you're right, which I doubt that will likely happen, because even though the technicalities of the matter is quite difficult to digest, what the court was basically saying is that you can't push her out of the house for this number of times. Even if you can suspend her, you can't suspend in a way that is now offensive to common sense. In any way, how long is she supposed to represent the people constitutionally? And what is the amount of time you're suspending her? She married him, and she said, no, this doesn't make any sense. Of course, people are arguing you have delved too far. At best, there'll be, maybe a retrial, but I'm not thinking that it will be totally vacated. I don't think so. I think the Court of Appeal will always want to do substantive justice, and I think substantive justice, everybody will agree, whether or not your sentiment flow with the senator or not, is that she should go represent the people, the good people of Kogi Central, I think. And
I completely, agree and understand the perspective of us not knowing if there's a stay of execution. If there hasn't been a stay of execution, what we refer to will be the last judgment in the matter. But those who argue that the judiciary in this case do not have the right to intermeddle within the affairs on the floor of the Senate, because they say that Senator Natasha Akpoti-Uduaghan was suspended because of overreaching duties, maybe because of the seat allocation issue and matters that happened on the floor of the Senate. How would you respond to that?
Well, I think, of course, there's clearly the duty of the court to interpret every law, and every policy that was done, and every matter that was taken, any decision taken, even outside of the courtroom, ought to follow a certain principle, right? So, it's judicial, they ought to be the natural to sack your employee out there. The court can sit into it and say, no, this is not how you ought to do what you did. So definitely the court has to interpret and listen to this matter. The problem with this particular case is that there have been a multiplicity of matters, filed by the Senate President's wife, filed by the Senator Natasha herself. Several of these matters are in several cases, some arguing defamation, some arguing one matter or another. And I think in general, this has made it very difficult. So people are asking, what is exactly happening here? Which of these matters is taking precedence? There seem to be several matters seeking basically directly. It would be sweeter if it was consolidated in one case, in one court, and you follow them line by line and say, okay, this is what we are listening to now, and this has been a big distraction. I think the Senate doesn't necessarily vote suspension, or at least abridge the time. 6 months is definitely too much, and it's a denial of the people of Kogi Central, like you rightly said, their right to be heard, to be represented. I think that's something that the Senate didn't definitely put into consideration.
It's simply a case of different explainers or explanation, especially of the law, and what we'll call explaining the rule of law interpretation. And that's exactly what we've seen. But I want to thank you so much for coming on board to break it down for us. Tomorrow is D-Day, so we're going to wait to see what will come out of tomorrow. But do you think, as a lawyer, do you think that Senator Natasha Akpoti-Uduaghan, who is equally one who understands the law, will actually make her way to the House tomorrow?
If you could advise, what advice would you prefer?
Yeah. I think so. I think I don't want to throw matters that are not necessary here, but I think there's been a lot of distraction, a lot of it from the senator herself. To be honest, she's a lawyer. I believe a fine one at that, and I feel like she's said a lot of things. There's been a lot of distraction. We left from whether the Senate had a right to ask her to sit where to sit, to somebody's trying to rape me. There's been several of these allegations, many of them unsubstantiated, I may say, right? Many of them unsubstantiated, and they've been all in the air. A lot of people are running after sentiment, left, right, and center. I would advise that because these are the same people, they are the same class of people, politicians. I would advise they should go back and do the job that the tax-paying Nigerians are paying them to do, and stop distracting us with trivialities, with unnecessary distraction. There are a lot of hunger, a lot of frustration out there in Nigeria. And I don't have sympathy for any of them. Not the senator, not the Senate president, none of them. These are, for me, they are birds of the same feathers, right? They are not fighting over the need or the desire of the ordinary Nigerian man. They are basically throwing muzzles and flexing. So I'm not one of those people who have sentiment on Senator Natasha. Absolutely not. And I don't even have for the Senate president. I think they are birds of the same stock. I feel like the political class are really alienating the people. on day by day. We see it, we experience it. As a practicing lawyer, you hear matters day in, day out. You're like, come on, we need to we need to be better as a country. So I think they should stop distracting us with their trivialities, focus on the matters that, we are paying them to do. And yeah, that would be my advice. And I think the Senate generally ought to come in this time and cancel or rescind their decision and take out the time from the court. The court should be listening and dealing with better matters, yeah? There are pressing matters that are begging the court to attend to. We are finding it hard to have dates, and we're using dates to entertain trivialities like this. I think this is a big distraction, completely unnecessary in my opinion.
All right, lead counsel.
Tax-paying Naira shouldn't go for this. Yeah, they should fund it with their Naira. They should pay because at the end of the day, you are wasting the Nigerian Naira on this matter that makes no sense in my opinion.
All right.
It's sad.
All right. Lead counsel, Robson Legal, Osigwe Ahmed Momoh. Thank you so much for joining us. And we look forward to tomorrow when she steps her foot into the National Assembly.
Thank you so much.
What will happen
for your time.
Yeah, that's right.